Good morning and good evening, and welcome to our first International Law Association lecture for 2022. I'm Dr. Ntina Tzouvala. I'm Associate Professor at UCL Laws and co-convener of the ILA lecture series at UCL. Our speaker today is Dr. Ntina Tzouvala, who is Associate Professor at College of Law of the Australian National University. Today, she will not speak about her recent monograph on capitalism as civilization, which came out with CUP in 2020, but rather her lecture is entitled Invested in Whiteness, the von Pezold Arbitration and the Question of Race in International Law. It is based on a paper she's currently working on and covers significant ground in an insightful way. She focuses on the 2015 ICSID arbitration against Zimbabwe, where arguments on racial discrimination in a post-colonial context were made and addressed by the tribunal. Now, Dr. Tzouvala will speak for 40 minutes. We will then have 20 minutes for questions. So please use the Q&A function to place your questions, and I will pose the questions to Ntina. So without further ado, I pass the floor to Dr. Tzouvala.
Hi everyone.
Good morning and good evening, and welcome to our first International Law Association lecture for 2022. I'm Dr. Ntina Tzouvala. I'm Associate Professor at UCL Laws and co-convener of the ILA lecture series at UCL. Our speaker today is Dr. Ntina Tzouvala, who is Associate Professor at College of Law of the Australian National University. Today, she will not speak about her recent monograph on capitalism as civilization, which came out with CUP in 2020, but rather her lecture is entitled Invested in Whiteness, the von Pezold Arbitration and the Question of Race in International Law. It is based on a paper she's currently working on and covers significant ground in an insightful way. She focuses on the 2015 ICSID arbitration against Zimbabwe, where arguments on racial discrimination in a post-colonial context were made and addressed by the tribunal. Now, Dr. Tzouvala will speak for 40 minutes. We will then have 20 minutes for questions. So please use the Q&A function to place your questions, and I will pose the questions to Ntina. So without further ado, I pass the floor to Dr. Tzouvala.
Hi everyone. Before I get started, of course, I would like to really warmly thank Dr. Tzouvala for this very, very generous invitation and introduction. And I also would like to thank Kat Balongung from UCL from helping us so much with all the practicalities. As I'm sharing my slides, I would also give me 1 second. I can't multitask, even though I think that I can. Okay, before I get started, I would also like to acknowledge, especially given the topics that I'm going to be discussing today, which is issues of land, race, and law. I would like to acknowledge that I'm zooming in from Canberra, that is the land of the Nawagal and Ngambri people. And I would like to pay my respects to their elders, past, present, and emerging, and to acknowledge that sovereignty over those lands has never been ceded lawfully, especially on the day that this event takes place. So thank you so much, Danai, for the introduction. And as Danai said, this is a talk based on a paper that has been accepted for publication and will be out within the next few months with the Journal of Law and Political Economy. So if you're interested in seeing the written version, it will be out soon-ish. First, I'll try to explain how I ended up so interested in this particular arbitral award. And basically the way I got there was partly through my book, which, if you have had the opportunity to read, does touch upon questions of capitalism but also on race. And the broader question, I guess, was how does international law deal with race and racism, besides the obvious, right? Besides the seemingly unequivocal prohibition of racial discrimination embodied in the International Convention on the Elimination of all forms of racial discrimination. In other words, another way of putting it is, where should I go in international law to find race and racism, right? And it will not come as a surprise to those who know me at all that I'm adopting a historical materialist approach to race and racism. This could mean, of course, a variety of things, and I'm really happy to hear counter arguments on what this might mean. But basically, the historical materialist argument about race argues that race and racism, race emerged as an analytical category, so as a way of seeing the world, and as a technology of power, as a way of managing the world and sorting populations in order to rationalize transatlantic chattel slavery and colonial dispossession. In other words, race and racism is a thoroughly modern phenomenon. It's distinct to all the practices of discrimination or religious bigotry or xenophobia. It is different and distinct to them, and it had a material, a political, economic matrix, even though, of course, today might have manifestations that go well beyond it. And one of the most famous articulations of this materialist understanding of race comes from Eric Williams. Eric Williams, for those who don't know, was a Marxist historian who wrote a monumental book called Capitalism and Slavery, in which he has this famous passage in which he's talking about enslaved Africans, obviously in the United States. And he says they were not slaves because they were Black. There wasn't some sort of primordial anti-Black animus that led to the enslavement of these people. Rather, they became Black. The category of Blackness was invented in order to justify their enslavement. And I can explain the way Eric Williams gets into this. What does this historical materialist general outlook mean in practical terms? In practical terms, it has meant two things for me. First, look for race and racism in international legal fields where we usually don't look at, right? Usually we look in international human rights law. In extreme cases, we look in international criminal law for race and racism. And my argument is, what if we look in other places? For example, international investment law. And the second consequence of this approach is that I'm not only interested in race as an argumentative trope. So by that, I mean that 12 scholars, for example, third world approaches to international law scholars, have shown how international lawyers can employ racialized tropes. So for example, some people being overly violent or barbaric or overly emotional in order to justify a variety of interventions. I am interested in that. I'm interested in race as trope, but I'm also interested in the way in which neutral and technical language, which tends to be the language of international investment law, nevertheless authorizes an equal distribution of resources, income, rights, violence between different groups. And this brings me to the von Pezold arbitral award, which is at the center of this talk and this piece. For those of you who might not know, this award came as a result to Zimbabwe's fast-track land reform program after 2000. So basically what happened in 2000 in Zimbabwe, there was a huge wave of land occupations. These land occupations were disproportionately, not exclusively, but disproportionately directed towards white land owners. And the von Pezold Pezolds, based on two bilateral, so the fund Pezolds had their investment initially occupied and subsequently expropriated, which is what the fast track land reform program did. They were expropriated without compensation apart from improvements. And the fund Pezolds based on two bilateral investment treaties, one between Zimbabwe and Switzerland and the other between Zimbabwe and Germany, brought a case in front of ICSID, which the three-person tribunal found for the applicants, so for the fund Pezolds, on all basically important points. They won the case. Generally, if you do know the fund Pezold case, one of the reasons you might know it is that one human rights NGO and a group of indigenous peoples tried to intervene as tried to make a submission as amici curiae, and the court at the tribunal actually rejected it. And the business and human rights people obviously have criticized this quite a bit. I think this is not the most interesting bit of this award. I think the most interesting bit of this award is that it found the expropriations of land that took place in Zimbabwe in the early 2000s racially discriminatory against the fund Pezolds. And I'm going to say this really quickly, but I'm happy to return to that. This is not the only piece of judgment in international law that found so. There is one more case that relies on extremely similar facts. There is obviously a different claimant, but the factual background is basically the same. This is the Campbell in Zimbabwe case that was adjudicating in front of the South African Development Court, which also found the expropriations to have been racially discriminatory against Campbell. So, and the other thing that I need to really flag here was that this finding of racial discrimination was not simply an obiter. It wasn't a passing comment that didn't have an effect on the way the case was decided. It was legally significant. And it was legally significant in two ways. First, the tribunal, quite unusually for an investment tribunal, ordered restitution as well as compensation. So for those of you who don't know, that's not a very common remedy in international investment law, but the tribunal said because the prohibition of racial discrimination is an erga omnes, they didn't say it was a jus cogens obligation. They said it's an erga omnes obligation. Restitution is in order. And the second reason it was important is a state responsibility, of course, reason, which is again based on the finding that this was a violation of an erga omnes rules. They denied, they basically did not accept Zimbabwe's defense of necessity. So Zimbabwe said this was an explosive situation. We had no other way than dealing with it than actually expropriating the land. This is a place, and I'm going to obviously come back to this, in which land is, and the question of land, it has been really, really deeply entrenched into questions of nationhood and into questions of race. We had to expropriate because the state was in danger. This argument was rejected on a number of grounds, including factual grounds, or whether there was indeed a state of necessity, but the argument was that in any case, based on the ILC articles on state responsibility, you cannot invoke a defense of necessity against erga omnes obligation. Before I move on, I want to say, I want to take basically half a step back. And this step back is going to be the following. In the rest of the paper, I'm going to assume that this was an extremely problematic finding, right? The fact that they said that it was racially discriminatory against white people. people might disagree with this thing that I'm taking for granted, and I'm happy to explain why, but I'm taking it for granted, and I'm trying to understand how on earth we got there. And I think we got there is my argument in this paper and in this presentation through three main argumentative moves. And crucially for my argument, I say that these argumentative moves are not unique to this award. They are not even unique to international investment law. They permeate international law as a whole. And I would say it permeates in general the way in which liberal legal systems have been dealing with questions of race and racism, at least in the Anglophone world, where I'm more familiar with domestic jurisprudence. And these argumentative moves are the following. First, a temporal fencing of racism. Secondly, a spatial containment of racism. And thirdly, the framing of racism as a political and irrational phenomenon. And I will go on and explain each move in turn. Basically, in a number if you read the award, the tribunal from the beginning does acknowledge, that there is a very, very long context to this dispute, but they say, at the end of the day, we have to check the applicable law. This context is interesting for framing purposes, but we can't let it decide the case. And also they say at certain point, you cannot say that this investment had anything to do with Zimbabwe's or Rhodesia's, in this instance, racist past, because this was, the investment was made in 1988, 80 years after Zimbabwe became an independent state. And therefore, you cannot possibly say that this investment had anything to do with the land situation and the entanglement of land and race in Zimbabwe. I think that especially the temporality claim is extremely unsustainable. And for those of you who perhaps are not aware of the full history of Rhodesia and Zimbabwe, I'm going to take 5 minutes and explain why I think this is a very interesting way of framing temporality and the idea of 1980 as this hard cutoff for race and racism in Zimbabwe. So this, of course, the history of Zimbabwe or of the people who live in Zimbabwe doesn't start with colonialism, but this is where I will start. Of course, people existed and had a history before colonizers arrived. But for our purposes, the interesting thing is, in 1889, Cecil Rhodes leads the incorporation of the British South Africa Company in London, which is given both property and administrative rights over both what was called at the time Northern Rhodesia, which is contemporary Zambia, and Southern Rhodesia, which is contemporary Zimbabwe. The impetus for colonization was basically the hope that Zimbabwe had minerals and it was going to be a mining situation the way South Africa had turned out to be. This turned out to be wrong very, very quickly, upon which point land, rather than mining, became the epicenter of colonialism and especially of settler colonialism. There was a number of successive ways of dispossession of the indigenous population, which were carried out by legal, semi-legal, and illegal measures. One very important moment is in 1918, when Lord Sumner, sitting for the Privy Council in a dispute between the corporation and the crown about who owned unalienated lands in southern Rhodesia, uses, unsurprisingly, the standard of civilization to say, well, whoever indigenous people had intervened in the dispute, to say that they owned the unalienated land. And Lord Sumner says, infamously, whoever owns the land, the natives do not, because they're too low in the civilizational scale for the common law to recognize their relationship to land as property rights. There is another wave of legislative dispossession in 1930, basically at the onset of the global financial crisis, where indigenous people are confined based on legislative fiat in reserves, and the land is not much and of inferior quality. And the third main wave of dispossession comes in 1969, so under Rhodesia, in which basically the government gave 50-50 land, 50% to white inhabitants, 50% to Black inhabitants. The trick here is at that point, white inhabitants were approximately 5% of the population and got 50% of the land. This was presented as an equitable solution to the race and land program. And basically, despite what the tribunal says a number of times, and that's an interesting repetition, the national liberation movement had the land issue really at its center. The tribunal on a number of occasions, you can word search it, says it didn't. The tribunal insists that the national self-determination movement was actually a movement for political rights and political equality. This is flat out just not correct. There is a deadlock. Neither the settlers who, as you know, in 1965 have unilaterally declared independence from the UK can win, nor the self-determination movement can win through struggle. So this is resolved through negotiation. The colonial power, Britain, is the broker. And in 1979, the parties reached the so-called Lancaster House Agreement. And the Lancaster House Agreement does a bunch of things. It reverts sovereignty back to the UK for a year. Actually, Zimbabwe doesn't become immediately independent. But more importantly for our purposes, it says that for the first 10 years after independence, so 1980 to 1990, Zimbabwe could only, the state could only acquire land through a willing buyer, willing seller situation. So basically, you could not expropriate land even under the conditions prescribed by international law, including, let's say, international investment law. Even if you gave compensation based on the constitutional arrangement reached in the Lancaster House Agreement, you could not actually expropriate land. This means in practice that in 1988, when this investment happens, Zimbabwe actually does not have the full range of sovereign rights under international law, even as international investment law acknowledges, right? It does acknowledge the prima facie right of states to expropriate based, of course, on a number of preconditions. And unsurprisingly, between 1980 and 1990, this clause expires, there has been extremely slow redistribution. Redistribution went extremely slowly, and it went extremely slowly in the 1990s as well, partially because, and this is not very often remembered, at the time, actually, Mugabe's government was in pretty good terms with the IMF and the World Bank, and obviously a mass program of land redistribution was not exactly on the card. So my argument is that obviously this idea that race and racism ends in Zimbabwe in 1980, especially when it comes to land, is a very formalistic way of seeing the matter. Even in the narrow reading that says, until 1990, Zimbabwe does not have the full range of sovereign rights a state has under international law. But that, I think, it's kind of like, I'm lucky that this happened, right? This is not an extremely good argument. It just happens because the investment happened before 1990. My broader argument is that this idea of race and racism as fully a product of the past ignores the very function of property rights, not simply under international investment law, right? Under all sorts of liberal legal systems or all sorts of legal systems, property rights as form of temporal bridges between past and present. To call something a property right is to recognize that the interest of a person or of a group of people over land, in this instance, should continue into the future, regardless of contingencies, and can only be disrupted through legally mandated, legally prescribed ways of expropriation. So in a sense, I'm saying what property rights do as a matter of definition when it comes to settler colonialism and racially unequal distribution of land, for example, or let's say all resources, is that it makes sure that the past is never actually fully past. An element of the past, of the pre-1980 situation in Zimbabwe, in then Rhodesia, now Zimbabwe, exists to this day through property rights that act as bridges, transfer claims over land, and especially claims of exclusion of others, so claims of power over other people from the past to the present and the future. So this idea that you can draw a line and say the year in which formal racial discrimination was abolished is the year racism ended, ignores the very function of property rights in domestic and international law. The second element I mentioned earlier was the temporal containment of racism. And the argument there was, so one of the things Zimbabwe tried to do in its constitution is it tried to say, sure, you should seek compensations from the former colonial power. Go and ask Britain for compensation for your land because Britain created this problem in the first place. Obviously, this argument did not fly very well with the tribunal, but also Zimbabwe tried to invoke the responsibility, not in the technical term, the culpability, let's say, of foreign actors in other bits. So the paragraph I have here is from the bit that discusses necessity, in which Zimbabwe tries to say, listen, we are in a dire financial situation. This dire financial situation has partly been caused by the international financial institution and by the former colonial power, and therefore, as I was saying before, the expropriation is coming as an expression of necessity. The tribunal was having none of it. As you can see here, it says, the international community was under no obligation to assist Zimbabwe. And I think in the same or in the following paragraph, it says something to the effect that, and actually the international community, Britain, did suggest to give some financial assistance to Zimbabwe based on particular conditions. And you can see that not only in this bid, but you can see this throughout the award, this idea that the international, being the former colonial power or international organizations and institutions had nothing to do with the situation in Zimbabwe and even in Rhodesia. This argument that, again, the main culprit when it comes to racial discrimination was Rhodesia. And when I say Rhodesia, I mean specifically the period between 1965 and 1980, where the settlers, the white minority, had declared independence from the United Kingdom, right? And this idea that everyone else did whatever they could do to help the Black majority in Zimbabwe, and therefore we cannot possibly say that there is any international complicity to that. So first, I'm saying, you know, this is a colonial situation. To say that the international had nothing to do in a context of settler colonialism, where dispossession begins with the British corporation and also with the Privy Council expropriating basically the Shona and Embla people from their land, is not, again, I think, a very credible reading of the situation. However, I also argue that this subsequent idea of the international community being unanimously opposed to the unilateral declaration of independence and to Ian Smith's rebel government is a very misleading reading of the situation. If you go back and read UN debates on the issue, this was a matter of intense contestation in the United Nations. And the contestation is between familiar lines. On the one hand, we have post-colonial states that already since 1963 are warning the United Kingdom, and they're saying the settlers are going to declare independence, and everyone is dismissing them in the UN. And on the other hand, Western states, especially taking, of course, their cue from the UK, that adopted a much more conciliatory stance towards the settlers. So from the beginning, the UK actually says, we are not going to use force to stop the unilateral declaration of independence. And indeed, there was only one instance in which the Security Council authorized the use of force, and it was for a very narrow situation. So they say from the beginning, we are not going to use force. This is 1965. Britain is generally not very shy to use force in Africa to stop its colonies from becoming independent. And even, as you know, there is, after 1966-67, a gradual imposition of sanctions against the white minority government. These sanctions come a little bit slowly. They're implemented extremely temperamentally. The UK knows already, we know subsequently based on reports to the British Parliament, that already since 1968, 1969, the UK knows that Shell is evading and BP are evading the sanctions. They are still doing business with Rhodesia. And here is a funny story. Two Western states that are not member states of the UN at the time, Switzerland and Western Germany, the two states of the BIT, they argue throughout, we are not member states of the UN. The obligations to apply sanctions do not apply to us. Western Germany prints the Rhodesian dollar throughout the situation. Swiss banks are rolling money from all over the world to Rhodesia. So my point here is that this idea that is throughout the award, but I would say it's general part of the perception of how Rhodesia was treated in international law and international institutions is somewhat misleading. There is a 1967 editorial in the American Journal of International Law written by the then honorary vice president of the American Society of International Law and honorary editor of the American Journal, saying, the settlers are doing nothing wrong. I don't understand why this is a threat. to peace and security, there shouldn't be any involvement of the Security Council in the situation. So relatively influential figures are actually at the time quite hostile to any idea that Zimbabwe should face sanctions. And my final point is that race in the word is treated as perfectly synonymous to skin color. A race means nothing else than a phenotype, and racism means nothing else than the irrational disliking of somebody because they have fair skin and flat hair, basically, in the case of Zimbabwe. Zimbabwe, in its submissions in a really weird and temperamental way, and this argument could have made much better, trying to push back against it. And basically they say, listen, we have no beef in particular with these people because of their skin color. It's just for historical reasons, white people have come to own a disproportionately high acreage of land in Zimbabwe, and land redistribution cannot possibly happen without impacting on the rights of white people disproportionately. They make it, as you can see, in a slightly strange way, because they say, well, if we had been colonized by the Japanese, we would be expropriating the land of the Japanese. But I think what they're trying to argue in a very convoluted way is race and property were inextricably linked in Zimbabwe. And that was not, Zimbabwe's fault, right? That was a legacy going all the way back to Cecil Rhodes and the period of colonization. And therefore, in any context, and I'm not necessarily, I have to say that because the word Mugabe stops thinking, I'm not defending the way in which the redistribution happened in 2000. And actually there is a lot of interesting critiques from inside Zimbabwe and why this was actually socially regressive. But the way the tribunal framed it's a word, it becomes to me really difficult to see how a post-colonial state or a state with existing patterns of settler colonialism could embark on a comprehensive program of land redistribution without falling foul of the prohibition of racial discrimination, the way the tribunal construed it. So basically what I'm saying is the tribunal there takes out entirely all questions of redistribution and political economy and ownership from race and naturalizes race, right? It says that race is not what I was saying earlier, a technique of power or a construction that was put to place to justify expropriation. Race is the fact that some of us are pale and the fact that some of us are not, right? It's a fact. It's a fact that exists in the world, and some people are irrational and they discriminate based on it. And actually, I'm saying they are separating race and property or race and political economy. That's not exactly true, because at some point the tribunal does say, oh, what you were doing between 1980 and 1990, the willing buyer, willing seller situation was perfectly fine. We don't understand why you felt you had to take more extreme measures. As I was saying earlier, the reason was that no redistribution had happened. No redistribution to talk about had actually happened during that period. But I think what is interesting there is this idea that the only way of addressing racial disparities in ownership and wealth is through market mechanisms, right? Only the market can be an acceptable way of transferring wealth from white to non-white people. And of course, as I said earlier, this was clearly not working. I think I prefer to hear other people's voices than mine. So I'm going to draw a line here. Thank you all for listening, and I'm looking forward to your comments and your questions.
Thank you very much, Dina, for this fascinating discussion. Indeed, and I will definitely read the paper. I look forward to it. This is indeed a very important case in international investment law, but international law in general as well, with Article 25 being interpreted. We have a few questions already, so I'm happy to start with the questions of the colleagues already, and I'm happy to continue with my questions, but also please, I encourage everyone to put your questions in the Q&A function. The first question here is, were non-white owners treated differently under Zimbabwe law? And I think the second question is I think you have addressed it to some extent, indeed, in the final part. Would your criticism be different if the phone Pezold would have been Chinese or Indian, and that a BIT was available?
Sure. So here's a funny story. Technically, they were not treated differently. So based on the law just says we are going to schedule XYZ properties for expropriation, and there was a limited numbers of properties by non-white owners, by Black owners, that were scheduled for expropriation. There is no question that the people who were expropriated were disproportionately white. It's interesting, though, because there would be legal systems, including the US legal system, in which once you schedule a non-white person for expropriation, this is not racially discriminatory, right? And the US gets away with that perfectly fine. In Zimbabwe, we start seeing suddenly patterns. It's like, oh yeah, this law is neutral at its face, but discriminatory in practice. This is an interesting way of going about doing things. I think we should do it more often. Laws that are neutral at this phase, but discriminatory in practice, right? And it is also true that the properties of Black people who were scheduled were disproportionately properties of people who were not getting along with the government, right? So this is not a program of expropriation that I think is defensible on a number of grounds, right? So that is the one thing. Would they treat it differently if they were Chinese or Indian? I don't think so. Like, because also, one of the things that I find particularly appealing about this historical materialist approach to race and racism is the acknowledgement that patterns of racialization don't need to be stable. And I don't think that the distinction between Black and white is some sort of primordial distinction. I think it emerged in the concept of European colonialism in the 19th century. I think if Chinese imperialism continues in Africa, and there's elements of Chinese imperialism in Africa, I wouldn't be surprised if elements of different forms of racism that do not hinge on white supremacy actually emerge, right? And I do think China, especially in its domestic affairs, we can see elements of racism that don't hinge on white supremacy emerging, right? Especially in the way it's China treats its Muslim populations in the West. So my answer would be basically no. They were not, though, Indian or Chinese, and they were not Indian or Chinese for historical reasons. The von Pezolds are not British. The von Pezolds obviously are from Central Europe, and they're an interesting family. The name might be familiar to some. They're also in the middle of a spat with, they lost with the Czech Republic over a bunch of castles that were expropriated from them after 1945. So they're not exactly, it's not your uncle's farm, right? The tribunal starts by saying this is the biggest tobacco plantation probably in the entirety of Southern Africa, and this is an aristocratic family of Europe, that goes back to like early modern periods, and they had castles. So they were not exactly small scale farmers. My point is, I can't see a way in which Zimbabwe did a successful distribution of land in which the land of these people was not partly expropriated. That's my point, that even in a much better designed expropriation program, I cannot see how the biggest tobacco plantation in the country would have remained intact. And that's what worries me here, that you don't need to defend Mugabe to see that if this precedent is taken up, any sort of redistribution becomes really difficult under international investment law.
Thank you, Dina. I wonder what you think, whether the tribunal could have done something differently, and what it could have done differently. I suppose you have indicated parts of that, but had it done a few of the things that you suggested differently, do you think it would have met the thresholds of a state of necessity, for instance, still? Or were there other grounds on which the tribunal focused? So the grounds of Article 25 of the Articles on State Responsibility would be met or not be met?
Right. Yeah. So obviously the tribunal is in a context in which necessity has been extremely restrictively interpreted, right? This is not their fault. I do think that a more substantial interpretation of what is racial discrimination could have totally done away with this hurdle, right? It could totally have done away with the issue whether this is racially discriminatory. I think this was not racially discriminatory, or perhaps some peripheral aspects of it were biased, but I think this should have been done away with. And I do think, and that's not only the tribunal's problem, right? That's a fundamental problem in which investment tribunals have dealt with necessity, going all the way back to most of the Argentina cases, that I do think there is plausible interpretations of necessity under which Zimbabwe could have explained, could have justified its actions. Yeah, I do think it's relatively, they would be arguing against the grain, but in the absence of a precedential system in international investment law, this is not necessarily such a big problem, right? You can argue against the grain. So I do think that the defense for necessity, especially because obviously there is a problem here, which is the non-payment of compensation, that I think, and it's difficult to say that there was no prima facie violation, but they could have accepted the defense necessity. Yeah.
Thank you. I have another question before, so it was sent to us before even the lecture. And the question is, are the improvements that we have seen over the past few decades sustainable? I suppose that also implies a separate question, which is, are there any improvements, first of all? And then if there are, do you think that they are sustainable?
Sure, thank you very much. Yeah, I don't think that. So these are BITs that are somewhere in the middle between what we call the first and the second generation. They are early 2000 ones. Based on Eco, the tribunal, that tribunal at least told us it doesn't care what the BITs say, right? The tribunal in Eco, and I'm not saying that this will be the position of all arbitrators, but they told us it doesn't matter what it says. It doesn't matter what exceptions are carved. It doesn't matter what you write down. They will award compensation, even in the absence of an obvious violation of international law, which I'm not the state responsibility expert, but I don't think that's a very common way of doing business in international law of state responsibility. So my answer would be that I am on record saying that international investment law, and in particular ISDS, was built having a very particular thing in mind. It was built having in mind constraining decolonization and constraining the welfare state, the Keynesian state. They couldn't do it at home in the 60s and the 70s, but that was the concern of those who built the system. And I think as long as it exists, a system that was built in order to constrain decolonization will turn racially skewed results, right? And I think von Pezold is an extreme case, but you can see them in other, because it talks about race, right? But you can see it happening in other bits, right? In Copper Mesa, the place where the dispute is happening was 60% indigenous and Afro-descendant. And they were being mined kind of to extinction, right? And again, the tribunal sided very, very clearly with the investor. Mm-hmm. So my answer is, I'm not sure which bits you have in mind, but again, ECOR tells us, to the extent that any case in investment law can tell us something, it tells us that the tribunals don't care, or that tribunal didn't care about carve-outs.
Okay, I have too many questions, so I will have to make choices, and I apologize to everyone that will not have their question asked. So, interesting question. Did Zimbabwe raise at all the idea of land redistribution as a special measure? They said allows these under Article 1, Paragraph 4, such measures to secure the adequate advancement of certain racial and ethnic groups are allowed and shall not be deemed racial discrimination.
Yes, that's an excellent question, also because it popped up in Campo. So in the other case, I was mentioning that was in a different tribunal. No, it wasn't. The issue, as far as I know, was not raised, or at least it wasn't raised in these very explicit terms of the ASIC, right? That it does allow for this type of measure. And Tendaya Chume has written a really good critique of Campo, saying that they got the case doctrinally wrong, that their reading of the convention is just, it's mistaken. So the answer is, the other aspect of this is, and I think Martins is partially raising it in one of his comments, the tribunal did think that redistribution in theory was fine. It was not at all convinced that redistribution outside the free market was fine. And it says that explicitly at some point. It says, what you guys were doing in the 80s and the 90s was good. This is extreme. And the word extreme is theirs. It's not mine. So I'm not fully certain that the tribunal would have bought it. On the other hand, and I do have to say that, right, Zimbabwe's submissions are a mess. Zimbabwe made it incredibly easy for the tribunal to dismiss. Do I think that if the arguments were better, they would have won? I don't, but I think they made it extremely easy.
Again, many questions, so I'll just try to pick some. So what argumentative work do you think was being done by Zimbabwe in comparing its redistributive program to the affirmative action policies of the US, New Zealand, Malaysia, Singapore, which backfired by allowing the tribunal to contrast those lawful policies with the unlawful racial discrimination by Zimbabwe?
Excellent. That's such a good question, Oliver. I think they were trying to de-exceptionalize what they were doing, right? I think they were trying to say, we are not some sort of weird or aberrational state. I think they had a sense about how they were seen by the international community, so to speak, at that stage, right? I think they know they're seen very unsympathetically. And I think they're trying to make an argument that says, we are not that different. We are doing things others are doing. Whether this is true or not, it isn't. And also, obviously, As you know, one of the arbitrators was Singaporean, another arbitrator was from New Zealand. I think they were trying to have a gesture to say, to particularly address these two of the three arbitrators, right, and say we are not that exceptional. I also think, by the way, that Zimbabwe said some unbelievable things in a bad sense, especially when they said, and that was unbelievable both politically and legally, when they said, yes, of course we wanted to create like a black landed elite. What is the problem with that? Everyone has a black land. All states have an elite that is from the majority. And I think that tells you things also about politics, but also it raised questions, for example, of public purpose, right? It really undermined the issue of public purpose. But I think they were trying to say they're a state like everyone else, and they're doing pretty unremarkable things. Whether that was true or not, I agree. And I agree that the arbitrators used it against them. Thank you, Oliver. Great question.
Another interesting question is, do you think the way temporality is inscribed in the existing rules is such that past injustice is unavoidable and unavoidably entrenched in the present?
Yeah, no. One of the things I tried to show in this piece is that the tribunal made a number of conscious choices or unconscious choices in construing temporality like this. They did not have to, especially given the very particular temporalities of the case. I think a tribunal that wanted to give it a different approach would have made much more of the 1988 thing, right? It wouldn't have said 1988 was after 1980, hence all good. Of course, I do think that, as I was saying earlier, that these argumentative moves are not happening in a neutral terrain, right? They're happening in the terrain, the purpose of which was to entrench these property rights in the light of decolonization, right? So I don't think that all argumentative maneuvers have equal chances of succeeding. All legal arguments are not created equal in ISDS, but I do think that the role of interpretation and the role of, let's say, judicial or arbitral choice is very stark here, because they could, if they wanted, have gone and done what David was asking earlier and done a more serious reading of the Convention on the Elimination of All Forms of Racial Discrimination, right? They could have done this work. But of course, as I was saying earlier, the reason they're there is not to do this work. The reason they're there, not the specific people, but the reason investment law in ISDS exists is to constrain decolonization. But no, I think the system has a bias, and it's a huge bias. I don't think they should let argumentative maneuvers out of the hook. I think argumentative maneuvers still have to happen, and the abstract principles in the treaty do not automatically justify concrete findings. There is a lot of work in the middle.
And I suppose this goes perhaps to another question I posed. As to, you have spoken already about some technical neutral language that we find, including in this particular field, investment law. And the question has been here, how does this, could you speak a bit more about some examples and how these in fact affect the distribution of wealth and rights along racialized lines? I think what you have just answered earlier has to do with how we interpret these technical terms. So that's one aspect of it, but I wonder whether you might want to give to the audience some wider examples about technical language that in fact allows for racialized lines.
Yes, so it's for me, the big parallel with von Pezold is Copper Mesa, in which you don't find an explicit, as I was saying earlier, you don't find an explicit discussion about race, and the tribunal never says, so in von Pezold, the tribunal says a bunch of things like, if the state doesn't intervene with the police, the citizenry will devolve into anarchy, right? The natural state of people in Zimbabwe is anarchy. In Copper Mesa, it doesn't say any of that. And for the language is very technical, but the situation is in a sense very similar. It's not land, it's mining. The miner appears, there is a lot of protests. The miner hires paramilitary forces. The tribunal accepts that the miner has hired paramilitary forces who shot live rounds at people. Obviously, this escalates the situation. The state can't do much. The state basically revokes the license. And there is a case, and the case is decided a year after von Pezold, so it's a 2016 case, in which a number of things come up, including full protection and security, right? And the tribunal doesn't say explicitly the slightly unpleasant things it says in von Pezold, but it says, well, listen, yeah, we understand you couldn't declare war on your own people, but we don't know what you could have done, but you should have done something other than expropriating. To me, this is a way of indirectly distributing violence in a racially skewed way, right? Because you are saying to the tribunal, to the state indirectly, you do have to use violence against your own people, even in situations where we acknowledge that the situation was partly created by the investor themselves. Because they hired paramilitary forces. So to me, and in a place, as I said before, the tribunal doesn't discuss it, in a place that is 60% Afro-descendant and indigenous, it says that, you know, the lives and livelihoods of Afro-descendants and indigenous peoples will have to be subsumed to open pit copper mining that is not very, very fun business. And when they push back, the state has an internationally entrenched legal obligation to use violence. So this is in my case, and if you read the award, you wouldn't even know that this is a place with 60% Afro-descendant and indigenous. You wouldn't know that it's not in the language. The language is not charged the way it is in von Pezold, but the unequal distribution is there, is authorized objectively, regardless of the good or bad language of the tribunal.
I mean, and that raises a point, I suppose, about how to improve things, because if that is something so embedded in the way that the arbitrators will approach the whole case, it has nothing to do with the technical language that is used in a BIT. It has to do with having a sense of the wider narrative, and as you say, a sense of the spatial, temporal limitations, and as well as the political phenomenon of racial discrimination. So, and with that, I think we will stop, unfortunately, but of course the debate is huge and it continues. Thank you all very much for attending this morning and this evening, and thank you very much, Dina, for this absolutely fascinating paper and for doing it so late in the evening at your end. So thank you very much.